Right. Hello everyone and a very warm welcome for today's session. In this session, I Jyotpreet will be talking about something very critical, very important for all of our exams this year, and that is the concept of divorce under the Muslim law. Now when I am talking about this topic, please understand ये topic suddenly important क्यों बन गया है. The reason why this topic has become so important is because abhi recently, just today, we've had a judgment from the Supreme Court which has stated or which has talked about one form of the Muslim law. अब प्लीज याद रखो, एक हमारे जो बहुत सारे फॉर्म्स है डाइवोर्स के अंडर द मुस्लिम लॉ, उनमें से एक है जी तलाक का एक फॉर्म है दैट हैज बीन चैलेंज्ड इन द सुप्रीम कोर्ट. अब सुप्रीम कोर्ट ने ये कहा है कि अगर हम इस तलाक के इस फॉर्म को देखते हैं या इस फॉर्म को समझते हैं, इसमें हमें कुछ as it is on the face of it we do not feel that there is anything wrong. So that is the first statement given by the Supreme Court in this case. But कौन सा फॉर्म है वो? Why do we have to understand it? And what depth do we need to understand this topic in? That is all that we are going to be covering today. So let us now understand the concept of divorce under the Muslim law as of in India. So please understand that the term used for divorce is talaq. अब अगर हम मुस्लिम लॉ की बात करते हैं तो हम डाइवोर्स का जो नाम है गिवन दैट इज तलाक. तलाक का मतलब क्या है? लेट्स अंडरस्टैंड. Right, talaq is an Arabic word. Now please remember that what language has the word talaq been picked up from? It has been picked up from Arabic. So Arabic word hai, and what does it mean? That its literal meaning is to release, to give up, right? So this is what is the literal meaning of talaq. Under Muslim law, talaq means repudiation of marriage by the husband. Now please understand that primarily अगर हम बात करते हैं मुस्लिम लॉ की, the primary right to now end a marriage lies in the hands of the husband. The wife does not have the primary right when we talk about the Muslim law to end an marriage. Now as a mode of divorce, talaq is the peculiar because a Muslim husband has an unrestricted right to divorce his wife without giving any reason. So this is what basically हमारा literal meaning of the word of talaq is. Now if we talk about just a further aspect, when we look a little bit in depth into the Muslim law, Prophet Muhammad had pronounced that talaq to be the most detestable before God of all the permitted things. So understand, in his wordings he had said yes, it is permitted, but it is the worst or the detestable form of things that have been permitted by God. For it prevented conjugal happiness. Conjugal का मतलब क्या होता है? Please understand, conjugal is nothing but the rights that husband and wife acquire when they get married. So right of companionship, right of intercourse, all of these now are within their conjugal rights, taking care of children and so on, and interfered with the proper bringing up of the children. So that is now the statement given by none other than Prophet Muhammad. Right, so this is what the very basic meaning of talaq is under the Muslim law. Let's understand a little further now. Now, understand, in India, there are specifically two broad categories of Muslim law. मतलब अगर हम बात करते हैं तलाक की in the Indian legal system, we divide it into number one, that is your extrajudicial divorce, मतलब कोर्ट के बाहर जो डाइवोर्स का फॉर्म है, and the second thing that will be your judicial divorce. Judicial divorce का मतलब ये है कि ये एक proper law, एक proper statute के through allowed होता है, and it moves according to that procedure. So in India we have the extrajudicial divorce. That will be, we are going to cover all the forms of it in the session today, and then we'll talk a little bit about what is the judicial divorce, what is the procedure, what is statutory method of divorce under the Muslim law. So let us quickly begin. First and foremost, let's discuss the various modes of talaq in India. So we are going to discuss 4 primary forms, that is talaq-ul-sunnat, talaq-ul-biddat, then we'll talk about talaq-i-Tafweez and ILA. So these are the 4 major forms of divorce under the Muslim law. अब हम इन सब को वन बाय वन डिस्कस करेंगे एंड ड्यूरिंग दिस आई विल टेल यू विच ऑफ दिस फॉर्म्स नाउ केम अप इन द सुप्रीम कोर्ट very very recently in the case that is taken up by the Supreme Court now. So starting first and foremost with talaq-ul-sunnat. अब talaq-ul-sunnat की अगर हम बात करते हैं, this has been divided into 2 forms. Please understand, talaq-ul-sunnat वो तलाक है that can be revoked. It can be taken back at any point of time before its completion. So we have a Hasan and the second form is Hasan. अब the very form or the exact name of the talaq that is being conflicted or that is in the Supreme Court as of now, that is being challenged, that is talaq-ul-sunnat in this Hasan. ठीक है, तो हसन क्यों चैलेंज हो रहा है, वी विल अंडरस्टैंड व्हाट एग्जैक्टली इज दिस फॉर्म एंड हाउ इज इट डेल्ट विद. सो अब इसको एक एक करके सारी चीजों को अब हम समझेंगे. सो क्विकली स्टार्टिंग विद हसन. नाउ हसन जो है इस फॉर्म के अंदर क्या होता है, देयर इज वन प्रोनाउंसमेंट, right? So there is one pronouncement of the term talaq and then the husband is given a time period of 3 tuhars. Tuhars क्या होता है? These are time periods of purity. So basically what is the time period of purity for the wife? This is the time period जहाँ पे the wife is not going through her menstrual cycle. So once the husband pronounces talaq, they get a time period of 3 tuhars, that is 3 periods जहाँ पे the wife is in purity. Now the husband has the right during this time period that he can critically in certain phases he can take back his pronouncement. अब इसको in detail अच्छी तरह से समझते हैं. Okay, so the husband has to make a single pronouncement of talaq during the tuhar time. Tuhar क्या है? Again, I am repeating that it is the time period of purity. The period of wife's purity, that is a period between 2 menstrual cycles, is known as what? It is the time period of tuhar. So he will make a pronouncement of talaq during the time period of tuhar. Then after this single pronouncement, the wife is to observe an iddat of 3 monthly courses. क्या टाइम पीरियड होगा? 3 months के लिए जो इद्दत है will be observed by the wife. Next, if she is pregnant at the time of the pronouncement, the iddat is till the delivery of the child. So please remember, एक होता है normal duration, एक होता है during the pregnancy. During normal durations, the time period is 3 monthly cycles. Whereas जब हम pregnancy के time की बात करते हैं, then it will continue till the child has been delivered. Now, during the period of iddat, talaq in the Hasan form by the husband is revocable. Now please understand, ये जो period है 3 months का, इस duration के time husband can revoke the talaq or he can take back his pronouncement of talaq. So this is regarded as the most appropriate and the most apt form of talaq under the Muslim law. Next we'll talk about Hasan. हाँ जी. Now during Hasan there are going to be 3 utterances of the term talaq. पिछले वाले में सिर्फ एक utterance थी, सिर्फ एक बारी utterance थी, but यहाँ Hasan के अंदर 3 utterances हैं. Why and how? Please understand, the husband has to make a single declaration of talaq in 1 period of tuhar. तो उसके अंदर तो उन्होंने एक बारी करना था, then they had to wait for 3 months time period of iddat. However, in this it has to be 1 single declaration in 1 period of tuhar. Then in the next to her, there is another single pronouncement for the second time. So this becomes my first time and this becomes my second time. अब ये याद रखना है, and what is critical about this form of divorce is कि during the first as well as during the second pronouncement, both of them may be revoked by the husband. मतलब दोनों में, पहले तुहर के पीरियड में as well as दूसरे तुहर के पीरियड में, जो आपकी whenever the husband is pronouncing the term talaq, he has the right to revoke the same. Right? So this is how this form works. However, it is on the third declaration, that is the third declaration, when it is made, the talaq becomes irrevocable. So it is revocable in the first and the second tuhr, but the moment your third declaration is made, here in this case the talaq becomes final or it becomes irrevocable, and the marriage dissolves and the wife has to observe the required iddat time period. तो ये है जी आपका specific concept that is right now being challenged. This is the form of talaq that is currently being challenged in the Supreme Court, and Supreme Court की अभी एक primary statement आई है that yes, as of now, on the face of it, prima facie, if we look at this form of talaq, it does not look to be controversial. Please understand, there is nothing wrong with it as of now. So please understand, आगे जाके complete जब तक हमारे पास judgment आएगी, then we may have a different stance or not. But today, there is nothing wrong with it as per the wordings of the Supreme Court. Let's move to the next form. Right, so the next form is talaq-ul-biddat. Now, talaq-ul-biddat की अगर हम बात करते हैं, this had been in news earlier. Why? So, because please understand, talaq-ul-biddat was also referred to as triple talaq or also referred to as instant talaq. Now, what happens is, over here you do not have any gap between the time utterances of the term talaq. यहाँ पे one after the other, it may be with or without any reason to the wife, and also it's not necessary that the wife was actually in the presence of the husband. यहाँ पे husband had a right that he could end the marriage just by 3 utterances of the term talaq. अब अगर हम बात करते हैं about this, please understand, we had a very prominent judgment by the name of Shaira Bano versus Union of India. Now, through this judgment, ये talaq-ul-biddat was struck down and declared as unconstitutional because it violated one basic perspective of our constitution, and that was article number 14, right to equality. Now, please understand, the Supreme Court had used its powers under Article 13, that is the power of the judicial review, to strike down this form of talaq. So, instant talaq or triple talaq is no more valid in the country. Rather, it is now a punishable offence for any man that gives a talaq in this form. So, this was about talaq-ul-biddat. Let's move to the next form. Right. So, the next form is talaq-i-Tafweez. So, इसको हम बोलते हैं delegated form of talaq. Please remember, the power or the right of the husband to grant to give a divorce to his wife can be also delegated, meaning वो ये power किसी और को भी दे सकता है. In this manner, the husband can also delegate this power to the wife. Now, this is basically what we know as talaq-i-Tafweez, and the person who he gives this authority to is called your talaq-i-Tafweez. अब इस फॉर्म के अंदर वाइफ को थ्रू एन अग्रीमेंट द हस्बैंड कैन डेलीगेट द पावर ऑफ गिविंग और द अथॉरिटी ऑफ गिविंग द डाइवोर्स. So, एक बारी let's quickly just go through this form. A Muslim husband may exercise the right of divorce his wife either himself or may delegate his right to another person, including his own wife. Divorce by such other person who acts as an agent of the husband under his authority is called talaq-i-Tafweez. And lastly, the authority is given to the wife under an agreement at the time of the marriage or even any time after it. अब ये चीज भी याद रखनी है कि इट कैन बी कंडीशनल और इट कैन इवन बी अनकंडीशनल, कि आप पूरी ही पावर दे देते हो या फिर कुछ कंडीशंस के अकॉर्डिंगली यू मे अलाउ. मूविंग टू द नेक्स्ट फॉर्म. Right. So the next form of divorce that we have is the form of ILA. Now in ILA, basically the husband will swear off, he will swear to God that he is not going to have any sexual intercourse with his wife, and if he does not have sexual intercourse with his wife for a time period of 4 months, then divorce can now come up by the way of ILA under the Muslim law here. So where a husband takes an oath, swears by God that he will not have sexual intercourse with his wife and observes 4 months of continence, he is said to make ILA. Now where the husband, having made ILA, abstains from intercourse with his wife for 4 months. Please remember time period kitna hai? 4 months. The marriage is dissolved with the same legal results as if there had been an irrevocable divorce pronouncement by the husband. तो यहाँ पे चाहे direct utterances नहीं है, but it will have the same effect as that of an irrevocable divorce in this situation. Now, these were the 4 major forms of divorce that are there under the Muslim law. इसके beyond 4 और हैं. Let's quickly go through those. Now, these are zihar. Now, please remember, zihar में क्या होता है? There is a comparison. Right. So, there is a comparison under a zihar. So, what happens is, यहाँ पे the husband compares the wife to any of the prohibited degrees, such as the mother, the sister, and so on. The fact that he does compare the wife or the conduct of the wife with any of these prohibited degrees now grants the right of divorce upon the wife. Second thing is lien. Lien is जहाँ पे husband now accuses wrongfully or makes a false accusation of adultery on the wife. What is adultery? That is where the wife has been now involved with or has sexual intercourse with any man other than her husband. इसको हम adultery कहते हैं. तो जहाँ पे इसी चीज के बेसिस पे गलत एक्विजिशन करी जाती है वाइफ पे, वहां लियन के ग्राउंड पे तलाक कैन बी टेकन. Then comes 2 forms, that is जहाँ पे म्यूचुअल कंसेंट है, दोनों हस्बैंड एंड वाइफ की म्यूचुअल कंसेंट होती है टू नाउ गेट अ डाइवोर्स. वहां पे पहला आता है जी खुला, जहां पे वाइफ गिव्स कंसिडरेशन टू द हस्बैंड एंड नाउ सीक्स अ डाइवोर्स. तो ये आ जाता है जी आपका खुला. एंड द लास्ट इज मुबारत. मुबारत में क्या होता है? दैट द डाइवोर्स इज बाय म्यूचुअल कंसेंट ऑफ बोथ द हस्बैंड एंड द वाइफ. तो यहाँ पे कंसिडरेशन है, यहाँ पे बाय म्यूचुअल कंसेंट है. सो मुबारत एंड खुला. सो दीज आर द लास्ट 4 forms of extrajudicial forms of divorce under the Muslim law. अब now when I was talking in the very beginning, you have to understand कि पहली चीज हमने ये बात की थी कि there are 2 major categories of divorce. पहला है judicial and the second one is extrajudicial. Right. So now we are going to move to the judicial category and talk about a very important law that made a significant change in the Indian scenario. And this is the dissolution of the Muslim Marriages Act 1939. Now, as a result of the Shah Bano judgment in India, there was finally a legal recognition of the right of divorce that was now given to the women through the Shariat law. तो यहाँ पे क्या है जी? यहाँ पे स्पेसिफिकली कुछ राइट्स हैं, कुछ ग्राउंड्स हैं जिनके बेसिस पे नाउ द वुमेन कैन. प्लीज रिमेंबर, इन द बिगनिंग आई हैड क्लियरली स्टेटेड कि प्राइमरी राइट किसके पास है? हस्बैंड के पास. नाउ टू गिव द वुमेन आल्सो अ राइट ऑफ डाइवोर्स came through this specific law, that is the Dissolution of Muslim Marriages Act 1939. तो इसके अंदर स्पेसिफिकली 9 ग्राउंड्स हैं दैट हैव बीन गिवन अंडर द लॉ, जहां पे राइट दिया गया है टू द वाइफ टू नाउ क्लेम अ डाइवोर्स फ्रॉम द हस्बैंड. So let's go through. The dissolution of the Muslim Marriage Act granted the right of divorce to a woman under the Shariat law. It is applicable to all Muslim women irrespective of the school to which they belong to. So ये नहीं फर्क पड़ेगा कि which form of Muslims do they belong to. Section 2 of this specific act contains 9 grounds on the basis of any one of which a wife married under the Muslim law may file a petition for divorce. So this was the judicial format through which now, or the statutory form by which women can claim a divorce in India. So now talaq-ahasan is what is being talked about. We will soon update you regarding any developments in this specific case. I hope you enjoyed the session and you were able to gain some important input and understanding of what all forms of talaq are actually there under the Muslim law. Thank you very much. For more such sessions, do subscribe to our channel on Hitbullseye YouTube. On YouTube